case. By the way, the principal's in here, Bonnie Poe versus Gail Cassidy Murhoff, and if I pronounce anybody's name wrong, you can correct me later. The defendant is also represented doing business as Arizona Animal Sanctuary Incorporated and Paws and Claws Pet Salon LLC. Okay, just for the record, let's all introduce ourselves. I'll go ahead and start with the defendants over here.
Kathleen Gratcheron, I'm counsel for Gail Murhoff, who is the defendant in this case. She is seated to my left. Would you give the court name, please?
Gail Murhoff.
Murhoff, okay, I mean it said Murhoff, I apologize.
That's all right.
Okay, and Kathleen Gratz, G-R-A-T-Z probably?
Yes, it
okay.
is.
All righty.
Good morning, Your Honor.
Good morning.
Jordy Duckler for the plaintiff, Bonnie Poe.
And your last name?
Duckler.
Okay, yes.
D-U-C-K-L.
Okay, I have seen that, okay?
I'm Bonnie Poe. Good morning.
Ms. Poe?
Have your payment.
Thank you very much.
Your Honor, I was first on the matter, John Gravina.
Oh, you're John Gravina. Okay, all righty. They don't have room for you at the table, do they?
Oh, they don't. They may
Oh, yeah, all right. Think about it. I'm going to read a couple things here as to why we're here, but think about how you want to present today. If you want to sit at the table and present, if you want your witness to come up here to present, I'm flexible either way on that. Unfortunately, we don't have a place to stand and do this, so when you're making your presentations, please sit because I need to be able to hear for recording purposes, okay? Okay. Well, this hearing is under ARS 12-2410 being held on application for issuance of provisional remedy, Rule 6D of Arizona Rules of Civil Procedure. The application is for the provisional remedy of Reflevin, which involves a claim by a plaintiff that his or her property has been wrongfully detained by the defendant. This hearing will be limited to the following two issues: the probable validity of the applicant's claim or claims and any defenses and claims of personal property exemptions of the party against whom such provisional remedy will operate, and number two, the existence of any statutory requirements for the issuance of any provisional remedies sought. Now, either side, have I read that wrong? Are we okay to get started here?
That sounds right, Jimmy.
Okay, all righty. I notice we have people in the audience, so I welcome you here, okay, but I please ask for silence throughout the process, okay? I don't mean to be rude, but the only people I want to hear from are the five that are up here in the front, okay? And I'm sure you know that. I apologize for even having to say that, okay? But I don't recognize any, don't know you, so anyway, welcome here to Florence.
Thank you.
Okay. So, plaintiff, do you want to begin this?
If you don't mind, Your Honor, and it's okay that I sit instead of standing?
Absolutely, because
It's easier
because of the nature of the microphones. I tried to, and just for an explanation, I tried to hear a case a couple of days ago, and it was almost inaudible, which can be very dangerous, even, in any case. So, and that's because they were just too far from the microphone. So that's what we have to deal with. I hope that's okay for both parties.
We have no objection, Your Honor.
Okay.
So this is, you've accurately stated in a sense what this proceeding is for. It's under two sets of Arizona statutes. The 2404 is the more generic provisional process statute that allows for provisional remedy, and that certainly is what plaintiff is here for today. The more specific remedy that we're actually seeking is possession, and that's under 12-1301, and those statutes underneath that. And that is what we will be presenting evidence on, exactly the issues that the court already identified, solely, in a sense, solely as to the identification of the property, ownership of the property, transfer of the property to the defendant, and then the request to have the property transferred.
Yeah, I have several pages of what you just read right here that I've been trying to educate myself on.
And I defer to the court in terms of, obviously, its knowledge of the statutes and of the cases. If you'll notice, in the application for the issuance of this provisional remedy, I tried to present to the court the cases that actually support those propositions. So I don't have a specific memorandum for the court. I'm relying on the memorandum of law that's in that application. Okay. In hearings I've had, a number of these in my practice, in the hearings I've had, sometimes it's the court's discretion to make it a evidentiary hearing, as I think is usually appropriate. Some courts don't want it to be evidentiary, and they just base things on affidavits that are submitted. I know that the defendant has a submitted affidavit, and I think it's probably appropriate that we make this an evidentiary hearing, in which I do have evidence to present.
Okay, I have no problem.
Okay, and other than that, that's really my only opening statement. To the extent that the defendant has any, I'm ready to proceed with my first witness.
Hold on 1 second here before you do. Okay, proceed.
Okay. So plaintiff calls Bonnie Poe. Yeah.
So, you want her to come on up here?
If that's
This
okay.
microphone does work, so
Oh, it doesn't work?
it does work.
Okay,
Yeah, I'm sorry.
Is this
I have you stop right here, so I swear you in a minute, okay? You swear to tell the truth, the whole truth, nothing but the truth regarding this hearing?
I do.
Okay, please have a seat up here. Pull the micro down to a comfortable level for you. My tall,
I'm
you
nervous.
You what?
I'm nervous.
Why?
I don't know.
I've done this last time.
May I inquire?
I still get nervous. Okay, go ahead, sir.
Thank you. Ms. Poe, if you could just briefly just tell the judge where you live, what do you do? Just to give me an introduction to who you are.
I live in Pima County, Tucson, Arizona. And
Proceed.
I'm a stay-at-home mom.
Stay-at-home mom, okay.
Ms. Poe, you understand we're here about what the court and the parties are calling property, which is a monkey named Latoya, correct?
Correct.
Okay, if you could identify that animal for the court and just give it a description, please.
She's a black cat capuchin monkey, and I've owned her for 15 years. Had her since she was a tiny little baby, about 2 weeks old. Purchased her in Missouri.
May I approach, Your Honor?
Yes, you may.
On my own. Thanks.
Thank you.
That's your
Oh, it's my copy, thank you.
Ms. Poe, I'm handing you what's marked as Plaintiff's Exhibit 1. Do you recognize that document?
Yes, I do.
Okay. Do you recall specifically what month and year in which you purchased the monkey Latoya?
I think it was February 21st, 2001.
And does that document help refresh when that was?
Yes,
So about how long, in a sense, have you owned that monkey then?
15 years.
Okay. Plaintiff would offer one. Ms. Poe, so this is the time in which I'm asking questions, you're answering questions, not just dealing directly with the court.
And sometimes I get caught up in that, so yeah, just ask me questions.
Okay, sorry.
That's okay, don't worry.
So plaintiff offers one, I don't know if there's an objection.
Pardon?
I don't know if there's an objection or not.
Doesn't appear to be.
Okay. And as to identifying the monkey, either was the monkey microchipped or did you have it microchipped?
Yes, she's been microchipped since she was a baby.
Okay, if we give the judge just a little bit of idea of what that entails and if the chip were scanned, what would it reveal?
It would reveal her chip number.
Okay, and who's the company that you would use to do that?
Avid.
Yeah. I'm handing you what's marked as Exhibit 2. Have you seen that document before?
This is part of her, the receipt,
Okay. This indicates, again, back to the purchase of the monkey.
the purchase of the monkey.
When was the monkey microchipped? Was it roughly about the same date it was purchased or shortly after?
No, you should have that in the file.
When was it that you recall? that the
I think
monkey-
she was like 2 years old when I got her chipped.
Okay. Since then, has the chip ever been changed, transferred?
Never.
Okay. So plaintiff would offer 2.
Mr. Drucker, does the defendant have these copies? So I don't have to worry about copying them.
No, thank you, Your Honor. We did just receive them here.
Just like I did.
Thank you.
For the next period of time from 2001 until about 2015, anything eventful in which there was anything about the monkey being unhealthy or going anywhere? Did you just have normal ownership of the monkey for that 14-year period?
Yes.
Okay. Then in October 2015, tell the court what happened in terms of briefly, in terms of the monkey's medical condition.
She became ill with valley fever, and I immediately took her down to Valley Hospital, and they diagnosed her with valley fever, and she was in and out of the hospital for like 3 days. And it was valley fever that they diagnosed.
Okay, before your next question, when was that, ma'am? I'm sorry.
October 19th, I believe.
Thank you.
And this is a veterinarian that was then doing some medical treatment for the monkey for that condition.
Right, and they weren't really equipped to have a monkey there. Have the zoo come in and help me.
And Hanny was marked as Exhibit 4. Do you recognize those documents? You don't need to look through them in detail, but do you recognize that sheet of documents?
I believe this is from the hospital?
Just if you recognize them as medical records.
Yeah,
for
medical
Latoya.
records, yes.
Okay, and if you look at the top, those dates seem to indicate about October 22 of 2015, is that right?
Where's the date?
Take a look on the first page, top left.
Yeah, 23rd.
Okay, and make sure you speak into the microphone.
23rd of October.
Okay, so does that comport with your understanding that this was about the time in which the monkey became ill and you sought treatment?
Yes.
Okay, plaintiff would offer 4. Shortly thereafter, did you actually then come to learn about Gail Muirhoff?
Yes,
Tell
Gail,
the court how you eventually heard of that name or that person and how you first contacted her, or she contacted you.
she got my number from somebody, and I guess it was posted on the internet because I had asked friends about valley fever, and she contacted me.
To the extent that helps with a refresher recollection, there's a chronology that lists some of these dates, but let the court know if your independent recollection is that you recall these dates, please let us know. Do you recall that the date on which you actually then were contacted by Ms. Muirhoff would be about October 23rd?
I actually have it in my cell phone, but I think it was before then.
Okay. And then around October 26th, did you then actually meet her?
Correct.
Okay, tell the court how you actually met face to face.
She drove down to my house because my mother just passed away and my whole household was very upset. And she offered to transfer to the veterinarian for me. And she made me aware that she was a veterinarian out of Missouri and practiced veterinarian. You know, she wasn't licensed here in this state, but she said she was licensed in Missouri, and she said that she owned Arizona Animal Sanctuary, and I had a full medical staff,
Okay.
and that she was a specialist in valley fever.
On October 26th, then, did Ms. Muirhoff actually take Latoya the monkey from your
Yes, she did.
premises?
Yes, she did.
In your mind, what was the understanding with her? Why was that? Why was she taking
It was just for a temporary thing because she was a specialist in valley fever, and she had a full medical staff that was going to help.
Did you have a discussion with her about those conditions, why she would take it and when,
Yes.
what she would do and when it would be
She
returned?
wanted an MRI done
Okay.
and some spinal fluid.
And in your understanding, once those things were done, what was going to happen with Latoya?
She should have been returned home on November 4th.
Okay, so did you have, at least in terms of a gauge of a time period, did you have an understanding about how many days or weeks?
Yeah,
you
it
might-
shouldn't have been more than 2 weeks at the very most.
It'll probably help that you wait until I'm done with my questions so that you know what you're answering, that's all. That's good. Okay. Did you and Ms. Muirhoff specifically discuss any time period? Days, weeks, months, anything like that?
It was a tentative for November 4th.
Okay, and did you discuss any conditions, like once the monkey is in this condition or has been treated in this way or had this procedure, now the monkey comes back to you? Did you discuss that?
Just the MRI and the spinal fluid.
Okay. And then, to your understanding, was then Latoya taken by Ms. Muirhoff to do those things?
Yes, she was.
Okay. Did you receive some communications with Ms. Muirhoff then in the early part of November, November 1st, 2nd, 3rd? Was there some messages between you?
Oh, yes, I have them all.
Okay, just in general, how was that correspondence? Was it by text? Was it by email, social media?
Text, email, when she came down for a visit.
Take a look at Exhibit 5, please. Have you seen that exhibit before?
Yes, I have.
Okay, is this a text or an email or a
This
posting?
is something that she posted on her social media.
Okay, so this is a social media post by her. At around that time, let's just say sometime in November, did you eventually see this post?
Yes, I was made aware of it.
Okay, and where it says Latoya is with me, I, through Arizona Animal Sanctuary, am taking care of medical needs only, does that comport with what you understood the agreement to be?
Yes, that's correct.
Okay. And in the next sentence, she will be staying with me for convenience reasons only, till at least diagnosis is complete. Does that comport with the agreement you had?
That's correct.
Okay, plaintiff will offer 5.
Your Honor, so far, no objections.
Right. I would hear you, I think.
I think so.
Okay.
Take a look at Exhibit 6, please. Could you identify that exhibit for me, please?
It's some social media post that Gail has posted on her site.
Okay, and again, if I represent you, this is roughly around that same time period.
October.
Have you seen this post as well? Have you
Um,
seen this document before?
I've heard about it. I
Okay.
stay off the social media.
Okay, this idea in there that this is language from Ms. Mirhoff saying,
Basically,
please, hang on. It's in that second paragraph, it says, please everyone continue to pray for Latoya and her mama, Bonnie. Do you see that? Okay, and so does that comport with the understanding that she understood that you were the owner of the monkey and that she was doing something for the monkey because of the valley fever?
yes.
Okay, plaintiff would offer 6. Was there a point in time in which you expected the monkey then to be brought back to you?
Yes, around November 4th.
And did that happen?
No. She showed up and said that she did a spinal tap and an MRI and that we were waiting for the results. And she told me and 3 of my friends at my house that they spun the spinal fluid and everything was clear and it looked good. And then we found out none of those tests were ever done.
Take a look at Exhibit 7. Have you seen that before?
Yes, I have.
Okay, does this look like a text message to you?
Yes, it is.
And is this from Ms. Mirhoff?
Yes, this is.
Okay, if you take a look at that first sentence, I want you to know that my intentions are pure and sincere, just the same as they were the day you asked me to come down and get Latoya to take care of her for you. Does that comport with your understanding you had with the defendant?
Well, I was a bit confused because I got this text from her after she called the cops on me for being at her house.
Okay, but my question to you isn't really so much about the cops being called or any event like that. My question is, does that sentence comport with the understanding you had with her?
Yes, it does, absolutely.
Okay, and the idea, the next sentence, Latoya is improving every day. As soon as she's better, your baby will return home to her mom. Does that comport with the understanding you had?
That's the
So
understanding that I had.
Okay, the agreement then you had with Ms. Mirhoff had to do with her temporary possession of the monkey for a certain event or set of events to pass, correct?
Mm-hmm.
Is that right?
That's correct.
Okay, and then once those events passed, then the possession of the monkey would come back to you.
Correct.
Okay, did you ever actually sell the monkey, Latoya, to Ms. Mirhoff?
Never.
In which anything of value, whatever it might have been, dollars?
Never.
Okay, did you ever actually gift the monkey, Latoya, to Ms. Mirhoff, in which you said, here, I want you to have it for all purposes?
Never.
Okay. In terms of abandoning the monkey, in which you said to the world, let's say, I don't want this monkey anymore, whoever wants it can have it, did you ever do anything like that?
Never.
Statements, actions, words, anything that would...
Never.
Okay, and again, it always helps for me to end the sentence so that you know what it is you're actually answering. I know you're eager to answer, you just gotta listen carefully, okay? You're doing good. So in terms of not having sold or gifted or abandoned the monkey Latoya to Ms. Mirhoff, your expectation was that the monkey would then be returned to you as your property, is that correct?
Absolutely.
Okay, and to this date, has the monkey been returned to you? And have you made several demands to have that return happen,
Yes, I have.
including through court proceedings?
Yes, I have.
To the extent that I didn't, plaintiff offers 7.
Can I hold you for a second? What is the date of this?
Unfortunately, the post itself does not have a date on it.
I have a date on my cell phone. You just
To
couldn't
the
print it.
extent that the witness has a recollection of what the date is, I think it was, did you say October?
That came in the day she filed the harassment order on me, just as I was leaving and
For the
yeah.
court's purposes, do you have like a month or a week in which that might have happened?
It was in October.
Okay.
October, no, November, I believe.
Most likely.
It's on my cell phone if you'd like me to get it.
That's okay, just to the best that you can recall. I don't really want you to have your cell
Okay.
phone up there and looking through it, so.
I do have it.
Take a look at Exhibit 8. Have you seen that exhibit before?
Yes, I have.
Okay, speak into the microphone, please.
Yes, I have.
Is this also a posting by Ms. Meerhoff?
Yes, it is.
This also seems to have a date of November 4th at the top. Do you see that?
Yes, I do.
Okay, and in that posting, it talks about, in the second sentence, we are here to assist the private owner in keeping their animal if at all possible. Do you understand that?
Yes, I do.
Okay, and does that comport with your understanding that she was the temporary custodian of the animal until the medical treatment or some medical procedure was conducted, or at least when you demanded the monkey be returned, and that never happened?
That never happened.
Okay, plaintiff would offer 8. It should have 3 pages.
Oh, you want them all?
Yes.
Okay. Sorry.
Did you eventually contact the microchip company and report the monkey as stolen?
Yes, I did.
And if you can inform the court about roughly when that was, if you take a look at your chronology, might help you refresh your recollection.
On 11/7,
Okay. Of
2015.
Okay. And did you ever learn that the microchip that had been implanted in the monkey had been removed?
I don't know.
Okay. As to this witness, plaintiff rests your honor.
Okay. Any other questions of the witness?
Yes, Your Honor, thank you very much. When you and Miss Meerhoff met and you gave the primate, Latoya, known as Latoya, to her, do you remember a document that you were first, is it email?
Electronically.
Electronically sent to you that contained the information that the Arizona Animal Sanctuary asks of all people who give their pets over to the sanctuary for the purposes of, in this case, medical treatment?
Objection. My objection would be that that's compound and it lacks foundation. I don't think the witness would know what she's talking about without the foundation being laid for that.
Okay.
All right.
Ask the question differently or
I will
proceed
ask
with another
the question differently. You and Ms. Meerhoff have had a number of Facebook contacts back and forth, or electronic contacts back and forth, haven't you?
Not very much.
Amongst those that you did have is a standard protocol of the requirements of an owner who brings an animal to the Arizona Animal Sanctuary. Do you remember any kind of an electronic transfer of that sort?
No, I never received anything like that from her.
Thank you. At any time, do you remember receiving a document from the Arizona Animal Sanctuary at the time that you relinquished custody of the primate Latoya to that organization?
Well, first of all, I never relinquished custody of Latoya, and I never had any documents from her whatsoever.
Thank you.
You saying thank you to the question, or are you
To
done?
the question,
Oh, okay.
no, Your Honor, I'll let you know.
All right.
You say that you called the microchip company, that's true,
That is true.
and you reported that the animal had been stolen,
Yes, I did.
and what was their response to that?
They have it, they wrote it down that she's been reported as stolen.
Have you ever heard back from them?
They know what happens when some vet scans her or whatever, that they're supposed to call them and let them know where the animal's located.
Okay, thank you. No further questions, Your Honor.
Okay. Did you read?
Yes, Your Honor, briefly. This idea that there were requirements of the sanctuary, in terms of, as you had any discussion with Ms. Meerhoff, did you ever sign what would maybe be considered like a formal document showing what those requirements were and that you agreed to those requirements?
Never.
And as to there being an electronic transfer that was referred to in Cross, was there anything in which, maybe not in paper form, but you signed something electronically?
Never.
Take a look at Exhibit 12.
Have you seen that document before?
Yes, I have.
That's
Your handwriting?
Yes, it is.
Okay. To whom it may concern was the idea that this was being addressed to someone that was,
She wanted me to write something so she could transport her that day.
okay, and the date on that, October 26th, does that sound about right?
That's correct.
Okay, so plaintiff would offer 12?
And it says
Hang on
temporary.
1 second, let's see if there's any objection.
There is no.
So if you-
Temporary.
I'm gonna make the assumption that I'll hear an objection when there is one.
Thank you. Sorry, Ms. Poe, do you still have that in front of you?
Yes,
Okay, do you see where it says, I am the sole owner of Latoya, does that comport with your understanding?
right.
And do you see where it says, I am giving Gail Meerhoff temporary ownership to seek medical care and any assistance needed? Do you see that?
Mm-hmm.
And again, that comports to the understanding of the agreement.
Take care for this one.
Okay, so there is no subsequent electronic signature or agreement to any condition?
Temporary.
Okay, thank you. Nothing further on redirect. Plaintiff has no further questions for the witness.
Anything else for the witness? Are you done with it?
Only one question, Your Honor. I see that your signature is on this document, and I see no other signatures.
It's been blacked out.
No need to.
I did not black that out. That came to me this way. Did anybody else sign this? Or is it something that you wrote and signed, but nobody else was there?
Oh, I had witnesses at my house that were there.
Okay,
In fact, they're sitting in the audience.
well, they aren't up here in the stand. Thank you, Your Honor.
You may step down, ma'am. Thank you.
Thank you.
Plaintiff calls Gail Meerhoff.
Okay. Ms. Meerhoff, would like to come up here, please?
She wants to be up there.
Yes.
I think so. All right.
You leave that way just a little. Please have a seat.
Yes. Is there, okay?
Ms. Meerhoff, do you recall being in a hearing in front of Judge Patrick Moran in the Pima County Justice Court on January 8th of 2016?
Yes.
And you recall that you were sworn in as a witness and a party in that hearing?
No.
Do you recall the statements that the court asked you and the statements that you made to the court? Any specific recollection?
I'm gonna say, I think I remember, yeah.
Okay, so I'm gonna ask you if you made certain statements and just let me know if you agree or disagree that you made those statements, all right?
All right,
To the extent that it helps you, you can certainly feel free to use Exhibit 13 to refresh your recollection.
okay.
Okay, and I'll point you to certain pages if that helps as well, too. Do you recall the court asking if you understood that the monkey Latoya was property? Do you recall that if you look on page 6? The bottom of page 6.
Oh, okay. Okay, I'm still not seeing it. What number?
Take a look at the bottom of page 6, line 25. The court, what reason if, I understand she may have signed her to for medical care, but you understand that this is property, correct?
I see that sentence.
Okay, and the is referring to the monkey Latoya. Does it sound familiar that the judge said that too? That you understood that the monkey was property?
That this is property?
Yes, do you see that? That the judge asked you if you understood that the monkey was property.
Property, not like an animal or a human. Yes, I understand.
Okay. Then if you take a look at the top of page 7, you agree with the judge, you said yes? correct?
Yes,
Okay, and when the court said it's her property, referring to Ms. Poe, you said yes, is that correct?
yes. I don't remember, but it's written here.
Okay. To the extent that you have different recollection, feel free to inform the judge if you do. But to the extent that that sounds correct, that is, the judge in that hearing said it is her property, referring to Ms. Poe, you said yes, you agree.
I do not agree because I don't remember that. I remember, saying that it was not my property.
Okay, so you have a different recollection than the words that you presented to the court in this hearing?
Yeah, because I've never seen this before.
Okay, so let's take a look at the bottom of page 7. If you see there, the court asked, you were going to keep the monkey for the rest of its life, and you said absolutely not. Does that sound familiar?
Yes,
Okay, so you recall saying to the judge that you would not keep the monkey for the rest of its life.
yes,
Okay, and then if you take a look at page 9 at the bottom, do you recall an open court saying to the judge, Latoya belongs to her? Do you recall saying that?
What number is that?
Take a look at page 9, line 25. You see your statement, Ms. Meerhoff, Latoya belongs to her, that her refers to Ms. Poe.
I don't recall it, but if this is taken from the recording, I must have.
I'll represent you, that this is a court reporter's transcript of an actual audio tape hearing. To the extent that the court needs to hear the audio tape, I think would probably be able to identify your voice as the person saying that.
Oh, yeah, yeah.
So to the extent that you at least have some recollection that you said those words, do you at least agree with those?
Yes,
Okay, so you agree that Latoya belongs to Ms. Poe?
as far as I know.
Okay.
And that's the best I can do. I don't have any proof, but as far as I know.
Sure, and to the extent that, I think you had indicated that maybe you were not placed under oath in that hearing, which would be a little odd, but to the extent that that was true, were you lying to the judge when you said that, or were you being truthful?
I absolutely do not lie.
Okay. Then if we take a
And
look
we were
at,
not sworn in under oath.
so, but to the extent that you weren't sworn in, did you feel like you had leeway to maybe fudge things or say things to the judge that weren't actually truthful because you weren't under oath?
Absolutely not, sir.
So regardless of the oath, you were still being truthful with the court?
Yes, sir.
Okay, take a look at page 11, please. Take a look at the top, lines 2 and 3. This is the court asking you a question. Has she, that's referring to Ms. Poe, requested you to return the animal to her? Do you recall that? Page 11, lines 2 and 3. Court asks you a question. Do you recall?
I'm wanting to read the whole question, if that's okay. And I'm very sorry. I'm ADHD and I'm dyslexic, so give me just a second.
I will be patient with you. I'm sorry.
Mr. Director, from my end, could you repeat the question you asked?
Of course, Your Honor, thank you. So do you recall on that hearing on January 8th that the court asked you a question, and the question was, has she requested you to return the animal to her? And the personal pronouns in there, the she is referring to Ms. Poe, and her is referring to Ms. Poe, and the you is referring to you. Do you recall that?
Yes, I think I do.
Okay, and then you have agreed, you said yes, correct?
Yes, I should have, yeah.
And as the court followed up with that, there were numerous occasions the court mentions, and you said at least twice that I know of. So am I correct in thinking that there were at least 2 times in which Ms. Poe demanded that you return the monkey Latoya to her? Does that sound about right?
To my recollection, yeah.
And then when the court said, so return the animal to her, answer to the court was, yes, sir, and that's fine. Does that sound familiar?
Where is that at?
On page 11, line 8, 9, and 10. The court says, so return the animal to her. It seems like, in a sense, a command. And then we're done, right? Your answer is, yes, sir, and that's fine.
If I remember correctly, that was a question from Judge Moran, and I agreed with him
Okay, and if we turn to page 12,
that it would all be done at that point.
and if we turn to page 12, do you recall you affirmatively saying to the court, you want to return the monkey to Ms. Poe? Do you see on line 16 and 17, I want to return the property? Do you see that?
Yes,
Are those your words?
I believe so, yes.
Are those true?
Excuse me, I've lost my place
Oh,
in
I'm
which of our exhibits we're on.
Okay, we're looking at exhibit 13,
Thank you.
page 12, line 16 and 17.
And
Nothing further than that. Oh wait, I'm sorry, plaintiff and author 13.
no objection.
What did you say? I'm sorry.
Exhibit address before.
I'm trying to be patient with you, don't worry, no rush.
Nothing further than witness, Your Honor.
Okay. Don't step down yet because
dear.
Your counsel wants to ask you some questions.
That's right. Just a couple of questions for you, Ms. Mirahoff. Have you ever, in your mind or to anyone else, said that you owned Latoya, the
No.
primate?
No, ma'am, I have not. It's any animal that comes
I
to
would
the
have
section.
the witness just.
Oh, I can't.
I'm sorry.
Just because there's a pause, you don't have to speak, okay?
Oh, okay.
Okay. You had an understanding with Miss Poe, I believe, didn't you?
Yes,
Okay. Actually, is that really true? Was it the Arizona Animal Sanctuary that had an agreement with Miss Poe, or was it you?
it was actually the Arizona Animal Sanctuary. I just happened to be a volunteer for the sanctuary, and in a bad way, I'm the president of the sanctuary. So, but it's the sanctuary.
Okay, I just wanted to get that out. And does the sanctuary, to your knowledge, ever take ownership, total ownership of any of the animals that are brought to it for medical care?
On occasion, yes, we do. Or the sanctuary, I'm sorry. It seems one and the same to me, but on occasion, we do.
But in this case, what is your understanding?
In this case, being as I am very acquainted with primates also, the idea of someone surrendering their primate due to the circumstances surrounding Latoya, the Arizona Animal Sanctuary in every way possible wanted to make sure that Bonnie, the plaintiff, I'm sorry, got Latoya back when she was able to go back, when the doctor released her, when the staff released her, just in accordance with the contract.
Okay, thank you. No further questions, Your Honor.
I I do, Your Honor. So Ms. Meerhoff, I think you had said Arizona Animal Sanctuary in response to council's question on cross, and then you said, in a bad way, I am president of the sanctuary. What's the bad thing about being president of that sanctuary?
I was being facetious, I'm sorry.
Okay, no problem. In terms, my understanding is that you actually then are the owner of the Arizona Animal Sanctuary?
No, sir, I am not. It's a corporation, a legal corporation, 501c3. There is no owner of the sanctuary.
Okay. Does it do things then without you, without your involvement at all?
There are several things that go on without my personal involvement.
Okay, and are you representing to the court that somehow the discussion that you had with Ms. Poe and the agreement that Ms. Poe has already testified to, and these correspondences between you and her and your statements in the court proceeding, those were all on behalf of Arizona Animal Sanctuary? Is that what you're telling the court?
The proceedings that went on in Pima County, the paperwork that I received was to me personally. So in Pima County, I was representing myself personally. Everything today and everything between Ms. Poe and I was for the Arizona Animal Sanctuary.
Could I have the witness examine Exhibit 7 again, please?
There's one page to that, correct?
There is one. Ms. Meerhoff, you take away Exhibit 7. I take it you've seen this before?
Absolutely,
And you-
absolutely.
You would agree with the first witness that this is a posting from you to Ms. Poe?
No, sir, it's a text message.
I'm sorry, a text message. And in it, it says, I want you to know that my intentions are pure and sincere, just the same as they were the day you asked me to come down and get Latoya to take care of her for you. Do you see all those pronouns? Do you see that sentence?
Yes, I do.
Okay, you agree you wrote that sentence?
Yes, I did.
Anything in that sentence refers to Arizona Animal Sanctuary? Is there anything in that sentence that refers to Arizona Animal Sanctuary?
Everything in that sentence, because that's who I was representing.
Okay, so in that text, the words themselves, Arizona Animal Sanctuary, are not there, are they?
I don't see him, huh?
Okay, so you're saying now, though, that somehow that text was only from the corporation, not from you?
I'm sorry, I don't understand the
Are
question.
you saying that this text is from a corporation and not from you personally?
Yes.
Nothing further, Your Honor.
Okay, you have another, and one more question to ask or not?
I have no more questions of this witness, Your Honor.
You're not being step down. Thank you.
So for purposes of 122404 and 121301, Your Honor, plaintiff rests.
12204.
I'm sorry, the statutes on the provisional process and on the writ of possession.
Okay,
Plaintiff rests.
thank you. Okay, defense?
Yes, we have two exhibits marked as defendants exhibits 1 and 2.
Yes, you may.
Thank you. May I put,
Does he have copies of those or no?
He will have.
And probably just to make sure there's no confusion, defendants exhibits are usually 101 and 102,
yeah,
just so that we don't have 2 exhibits 1 and 2 exhibits 2.
actually,
Did you mark those at all? We could go A and B actually.
that's what I'm used to. Oh, thank you.
Is A and B okay?
A and B is fine.
Yeah, okay.
Thank you, Your Honor, just so that we don't have confusion in the record.
Record show the defense counsel is marking exhibits as we wait.
May the record show that I am showing these to the opposing counsel.
Okay.
And might I approach the word the clerk? Thank you.
I assume it's, you got your own copy, right? Besides that, or do you need one printed up here?
I will ask for the witness to be able to look at that when I do it, when I put it on.
Okay, my question is, he's got a copy, do you have another copy of this? Okay, good, so I don't. All right, now proceed.
Okay, thank you, Your Honor. I think that the court,
You may sit and do this, that's fine.
okay, thank you. I believe that the court will come to the conclusion that today's hearing is less about the possession or less about the return of a primate or property, as the law in Arizona calls it, and more about a contractual agreement between parties. Furthermore, I think that the court may come to the conclusion that the real parties in interest have not been served with this information, nor are they here today to be witnesses for the court. Thank you, Your Honor.
Is that your case, ma'am? You not gonna call any witnesses?
I am going to call him.
Okay.
This was an opening statement,
Okay,
and I'm
go
going to
ahead.
call Ms. Meerhoff to the
Okay.
stand. Thank you, Your Honor.
Come back up, Ms. Meerhoff. You're still under oath, ma'am. You probably don't have to be as close to the mic.
What was wrong, maybe?
You were uncomfortable with that, and that's fine. I'll let you know if it needs to get a little closer.
Would you please give us your name?
Gail Meerhoff.
Okay. Can I call you Gail?
You sure can.
Okay.
I would actually object to that, Your Honor. The first name basis in a court.
You know what, in some cases in my court, maybe we do that on a smaller level. I don't consider this a small level case. This is a big case. to
No,
me
this is a pretty big
and
case.
to all of you, okay, so let's go with Mr. and Mrs.,
Okay.
okay?
Fine. Thank you. Okay.
Okay.
Mrs. Is it Mrs. Meerhoff?
Yes.
Okay. Thank you, Mrs. Meerhoff. Where do you reside?
At 8176 North Dead Man's Gulch Road in Florence, Arizona.
And is this in Pinal County?
Yes, ma'am.
All right. Did you bring a primate known as Latoya to this location, meaning into Pinal County, for medical care?
And 24/7 intensive care. But yes, medical care and 24/7 intensive care. And yes, I did bring her to Pinal County.
Okay, before you brought her to Pinal County, had you had text messages or other electronic communication with the pet's owner?
Yes.
And who was that?
There was a post on Facebook showing pictures of a primate that was very, very ill. The post also said that the primate...
I'll object to this listing here saying it's not responsive.
Huh?
I think the question was just who was them.
What?
Okay,
Who was that?
so that's the question again.
Who was that? Who was the person?
First contact was with a lady named Hiki Kustin. And we have paper there.
I know that.
I'm
But,
sorry.
was she ultimately the owner of the primate?
No, she was not. She's just the one that brought Miss Poe and myself together.
Okay, and so Miss Poe is who?
Miss Poe is the owner of Latoya the primate.
Okay, and I know that we've probably been a little sloppy here in saying I, me, and so forth. Actually, who were you representing?
I was representing the Arizona Animal Sanctuary.
And are there other people who volunteer for the sanctuary?
Yes, ma'am, there are.
Is there a board of directors?
Yes, ma'am, there is.
When you went to pick up the monkey and bring it back into Pinal County, did you have the authorization from the board of the sanctuary to do that?
Normal day-to-day operations, I don't need to clear it, but in this circumstance, it was the very first primate we had ever taken in, so yes, I did have permission from the complete board.
Okay? When you bring an animal in for medical treatment, and as you say, round-the-clock care, what is the first thing that you do with the owner?
The first thing, we enter into a contract. There has to be a contract, a surrender of the animal to the sanctuary. That is the only legal way we can provide medical care through a veterinarian or any other source that is needed.
All right, I have Defendant's Exhibit A in front of me. Will you take a look at that and refer to it only if you need to refresh your memory?
Okay,
Thank you. Do you recognize this?
yes.
What is it?
This is an electronic transmission that I sent to Miss Poe prior to the arrangements of picking up LaToya.
There is no date on this, nor is there time.
Yes, Your Honor, this was...
And wait for the witness to actually have a question, Your Honor.
Oh, I'm sorry.
Thank you. Can you remember, and you're under oath, can you remember about when you made this electronic communication?
This one was made on the 25th of October, directly after Miss Poe called me and asked me to please come and get the primate because she feared that it was dying.
And how do you know that it was received?
The only evidence I have of it is Miss Poe told me she thought Hiki Kuston and some other people had hacked into her Facebook, so we were going to have to communicate mostly by phone or text message, and that her roommate or housemate, Lori Stockton, would also be responding to any posts to let me know that Bonnie received them.
Okay, and in this case, is there any evidence in the paper that indicates your electronic communication? Is there any evidence that it came to her household? Look at the bottom of the page.
No, there is no evidence. All I know is that it was either received on a smartphone or a computer and then responded to by Lori Stockman, her housemate.
Okay, thank you. What does this communication say? What is it meant to say? What is this? Why did you send this to the owner?
This is a condensed version of the complete contract that if we have to electronically present to the previous owner of the animal in order for them to know exactly what type of a contract they're entering into, and that under all circumstances, if any way possible, the animal being surrendered can be returned to the previous owner, that is our intention, is to help the previous owner and help the animal.
When you and the owner finally met and you took the monkey into, I'm going to say custody for the sanctuary, did you then have the contract with you?
Yes, I had a written contract that day, and Miss Poe wanted to write in her own words. I'm not sure, I do not think she read the contract that I had brought with me in paper form completely, so she wanted to write in her own words because of her love for her animal. She did want to make sure that everything would go the way she wanted. That's my belief.
Yeah, but that's an opinion.
Oh, yeah, sorry.
Okay, so, we've seen this, her letter to the sanctuary before. Because the plaintiff has given it as a plaintiff's exhibit.
Yes,
Okay. I am now looking at Exhibit B. Do you recognize this exhibit?
yes I do, yes I do.
Okay, and does that spell out the entire contract?
Yes, this is our standard contract. Whether we take an animal in for end of life, for medical care, or for medical assistance, or to just help the previous owner understand their animal, and we do provide any assistance to the previous owners or owners to help them understand their animal and what their animal needs to survive.
Thank you. And is this also where Ms. Poe put her signature and her concerns or her love for the animals?
Yes, ma'am.
Okay, where?
Oh, I'm sorry. On the back of the contract, Ms. Poe wrote in her own words and wrote her name and then signed her name and dated it, and then also gave me her phone number.
Okay. So, in fact, she calls the custody agreement temporary ownership, does she not?
Yes, ma'am.
All right, then let's go on and start talking about what it is that the sanctuary actually did. And maybe, well, okay,
Okay.
all right. So, you've identified yourself as a volunteer for the sanctuary.
I'll object on relevance of this line of questioning on her, what the actual treatment of the monkey was, or her qualifications aren't one of the issues in front of us.
That's true, sustained.
Good enough. In your dealings with Ms. Poe and with her property, in your opinion,
I'll object to that the witness's life opinion, Your Honor.
Sustained.
okay, but witness is a member of the community of folk who are animal lovers and other folk who have sanctuaries, and as that, I ask that she be allowed to give her opinion.
My objection would be on relevance, Your Honor.
Sustained.
Okay, fine. Thank you, Your Honor. I then have no more questions other than, the sanctuary then accepted the animal as per the agreement.
Yes, ma'am. The sanctuary did. And
And is the animal still being cared for under terms of the agreement?
as far as I know, she is. She is not.
Thank you.
And-
Thank you. Okay, no further questions, Your Honor.
Oh, wait, I'm sorry.
No.
Thank you. Just briefly, Your Honor. Ms. Mierhoff, take a look at Exhibit B again. Your two-sided document in which you testified already that there is a typed version of some statements on the front of Exhibit B and then Ms. Poe's handwriting on the back, is that correct?
Yes.
Okay, so on the front of Exhibit B, that typed version, does that, are any of those words addressed to Ms. Poe herself? To whom it may concern, is that addressed to Ms. Poe?
Yes, sir. Every word on that page is addressed to Ms. Poe.
And did you see her name anywhere on that page?
No, sir.
Okay, and do you see her signature anywhere on that page?
Not on the front of it.
Okay, do you see a date anywhere on that page?
No, sir.
Do you see anything in which there is like a place for initials or a place in which someone who would have read those words would be able to agree to them in writing? So listen carefully. In terms of the writing on that page, Do you see anything in there in which someone in their own writing, let's say by an initial, a signature, an X, in which they would be able to say, I agree to these terms? Do you see anything there?
Yes, I do. At the bottom, they could write actually anywhere on the page. I don't care.
Okay, but my question, you're listening to a different question. My question isn't what they could do. My question is, do you see anywhere on there where that has been done?
Not on the front of it.
Okay, so you don't see any initials, you don't see any signature, you don't see any X or any indicia or mark by any person.
Not on the front of it.
Okay. And then in terms of that, those conditions then being something that would apply to the monkey Latoya, do you see anything on that page in which it refers to Latoya?
Every word
Okay, do you see
talking about an animal refers to Latoya.
Okay, do you see the name Latoya on that? On the first page? Take a look. Take a look.
Just ask you, I got it memorized. I've been using this page for years.
So my question to you is, do you see the name Latoya on there?
No.
On this back of this, is it your representation that this handwriting by Ms. Poe somehow incorporated these terms from the front page into her signature? Is that your understanding? Take a look at her handwriting. See, let's go over it fairly carefully. It says, I am the sole owner of Latoya, 13-year-old female caption. Do you see that? I'm sorry, you understand?
Yes.
Okay. And do you see anywhere in that part of the sentence that refers to any condition or provision of the front page? Anything about the sentence, I am the owner of the female caption Latoya, does that refer to anything on the front of that page?
Yes, sir, it does.
Point out to the court what words it refers to on the front page. We were talking about just that sentence. I am the sole owner of Latoya.
Your Honor,
Ownership of a
object, that's not
privately
the
owned animal
complete
or pet.
sentence.
Overruled. You can answer the question.
Okay, and go slow so the judge can hear you, please.
Okay. When receiving ownership of a privately owned animal, pet, or exotic.
And then where it says, I am giving Gail Meerhoff temporary ownership to seek medical care and any assistance need to care for Latoya, where are those words or those provisions on the front of that document? Are they there? Are Ms. Poe's words that she wrote out, are they on the front of this document?
I see no reason that they would be.
No, but
I don't get it.
This is an easy question. Are they on the front of the document? Yes or no? Her words. Are those words on the front of this document? Yes or no?
Her exact words, is that what you're asking me?
That's correct.
Oh, well, no, none of this is on the front.
That's correct. Okay. So now.
I'm sorry,
Okay. No problem. Just listen to the questions. Is there anything on the handwritten part, including where the name is or the phone number or the date, in which it says something like, I agree to these terms on the front, or I understand these terms on the front, or I have read the terms on the front, or they are part of my agreement or my understanding? Anything there? Let me say it again so you can.
Is there anything, is there anything written there
Try it again.
that says she's agreeing? Is that what you mean?
Yes, so look on the back page,
Mm-hmm.
the handwriting.
Mm-hmm.
Anything there that says, I agree to the words on the first part of the page?
The whole paragraph.
Where does
To
it say?
me, says she agrees to the contract.
Okay, and you may have missed.
Because it's just a very short version to me of the specific version on the other side.
You may have misheard my question. My question isn't what you believe, and my question isn't your opinion or what you feel. My question is, are there words there that say that?
Yes, the whole paragraph.
That says, I agree to these provisions?
The whole paragraph.
Okay, and the exhibit actually, nothing further. Okay.
Certainly, simply to look at that part again, and I know this is picky, but look at Ms. Poe's written statement, and the whole sentence. Would you read that to us, the whole sentence?
I am the sole owner of Latoya, 13-year-old female capuchin. I am giving Gail Meerhoff temporary ownership to seek medical care and any assistance needed to care for Latoya.
Thank you. And does the front of that same document say that the animal sanctuary will take temporary ownership to seek medical care and any assistance needed to care for LaToya? Not the same words, but similar words.
The front of the document has the same meaning. It also implies,
I would object to the witness's interpretation of the
It's
document.
okay,
It
we
speaks for
settle
itself.
down.
All right.
Thank you.
I don't mean to,
Right, and we understand, of course, that this is not you personally, that this is the sanctuary.
Objection, argumentative, and leading.
Nothing further. Thank you, Your Honor.
Oh, yes, you may, I'm sorry.
No, we have no other witnesses.
To the extent it's necessary, Your Honor, plaintiff has a very quick rebuttal witness.
I'm sorry?
To the extent it's necessary, plaintiff has a rebuttal witness. Okay, thank you. Plaintiff calls Bonnie Poe. Can the witness be handed exhibits A and D?
I see why you're here, Mr. Gravina. No, I don't. You're still on your own.
Ms. Poe, if you could take a look at exhibit D, please. You've seen that document before, correct?
Just here recently.
Okay. Did you sign that document?
I never signed the back of this document, but I recognize this, that I signed on a piece of paper, and it's obviously that she's
Hang on.
covered it, put it on there.
Let's do this maybe more in detail specifically. Look at the front page of the document. Did you sign that document?
Never,
Did you agree to the terms of that document by an initial or a mark of some type? Did
never.
you say words to Ms. Muirhoff, I agreed to these conditions, these terms on this first page?
No,
Did she read them to you and ask if you agreed and you nodded your head or said, yeah, that sounds
No.
about right? Take a look at the back page. Would you agree that that's your handwriting?
yes,
Okay. Would you agree that that's your name?
yes,
Okay. Are any of those words in a part of an agreement of what was written on the front of this document?
no.
Okay.
I've never seen this document until she put that on the back.
Did you hear Ms. Muirhoff's testimony on direct in which she talked about a phrase called a complete contract? Did you hear that phrase?
Yes,
Did you ever engage in a complete contract with Ms. Muirhoff?
never,
You heard her say a written contract in paper form. I think that was part of her testimony. Did you ever sign a written contract in paper form with either Ms. Muirhoff or with Arizona Animal Sanctuary?
no. This is it right here. This is all I wrote, and she put it on the back of this.
In any of your conversations with Ms. Muirhoff, either by text or by social media posting or email or face-to-face or over the phone, did she ever say to you words something like, I represent Arizona Animal Sanctuary and I speak on their behalf?
She's really big into the social media, so I'm not sure, but I think that's out there.
Okay, but okay, so let's go maybe more specifically in terms of the face-to-face conversations when she came to your house and took LaToya into her custody. Did she say, I am doing this as Arizona Animal Sanctuary?
From my recollection, she said that she owned Animal Sanctuary, whatever she called it.
Right, so listen carefully to the way I'm phrasing it. Not her connection, not that she owned it, or that she was a board member, or that she had some relationship with it. But in terms of, as I am taking LaToya, I'm taking it on behalf of them, that's who's taking the monkey is the sanctuary. Did she say anything like that to you?
To my recollection, you have to remember I just lost my mother that week, and I was
Okay.
a mess. And she showed up and she offered to help me. She mentioned the Arizona Animal Sanctuary, and she said that she would help me, and she was telling me how sorry she was for my loss because I was a real mess when she showed up.
Okay, and as to then the word, take a look at the front page of Exhibit B on the meeting date in which she came and took the monkey, and that let's say, right afterwards in which you were corresponding with her, did she ever read any of those words to you?
No.
Anything about to provide the best possible fulfillment of life for the remainder of the animal's natural life before the animal will be
I had
released?
never seen this here until recently.
And not only am I asking really in the sense of you've seen it, I'm talking about, did she ever say anything to you that indicated LaToya would be with her or with Arizona Animal Sanctuary for the remainder of its natural life?
Never.
And would you
No.
have ever agreed to anything like that?
No, I would not.
Okay. And in terms of, if you take a look at the very bottom of Exhibit B, that first page, upon relinquishing ownership of my animal to Arizona Animal Sanctuary, do you see that?
Yes, I sure do.
Okay, in anything, conversation, writing, statement, in any form, have you ever agreed to relinquish ownership of your animal to either Ms. Muirhoff or Arizona Animal Sanctuary?
No, I would never do that.
Nothing further.
You got the opportunity to ask questions of this witness, ma'am.
Thank you very much. Did you, when you talked with Ms. Muirhoff, did you believe that the primate LaToya was dying?
No, she's never been incoherent. Her problem was her limbs were seizing up on her. And I was worried that there was going to be some paralysis. And she told me that she was an expert in valley fever. She told me she was a vet. She told me she was a doctor. She told me she had a full staff. And I trusted her. I was out of my mind. I just lost my mother. And we had a bunch of people at the house, and I was so upset, just bawling. And she contacted me, came to my house and picked her up. And I told her she was an angel. I trusted her. This is like my
Thank
baby.
you. I mean, condolences on your mother. That's a terrible thing to go through. And
And have her do something like that.
Al, please,
Wait for the question.
I'm going to ask you a question, okay? All right. So it is your testimony that the document you wrote in your own handwriting,
Yes.
and that is Exhibit B, the back of Exhibit B, yes. That is your handwriting,
This document
The
is
question
on a
should-
piece
the
of
question
paper.
is it not?
Oh, yes, I
Okay.
wrote that, yes,
Okay,
but not
thank you.
on the back of
Okay.
this, I did not.
Okay, thank you.
She
Yeah,
put it
you've
on.
already testified to that, thank you. I just wanted to make sure it was your own handwriting. And that's all I really wanted to ask you about that. I am sorry about your mother. I realize that you may have been in a lot of
I was,
pain.
I still am, very
Yeah,
much.
I'm sure. At any rate,
No redirect.
But I do have one question.
Hang on. You're a witness. You didn't
What?
answer a question. Just wait. I don't know if she is done with cross.
I have not, no, I wanted to ask
I
a
think she's still
question.
not on, but
Thank you.
right, if you need, I'll give it back.
I wanted to know what the actual condition was of LaToya that made you turn her over to another party.
So I'll object on the basis that it's outside of the scope of the rebuttal examination. And relevance as well.
Did you voluntarily give LaToya to the sanctuary?
No,
Oh,
I voluntarily let Gail transfer her for medical reasons only. I told her I hadn't slept in like 4 or 5 days because I was so upset about losing my mother, and she offered to come down and do that for me.
but you, oh, okay, I'm not gonna follow that up. Okay, thank you very much. No further questions.
No redirect, Your Honor.
No regrets, okay, you may step down.
Plaintiff rests this rebuttal case.
Okay, I'm sorry, I didn't hear that, sir.
I'm sorry, plaintiff rests their rebuttal case.
Okay.
Your Honor, I don't know if, I didn't hear if defendant actually offered A and B into evidence.
I am offering that to evidence, Your Honor.
You are?
Yes,
Okay,
thank
I
you.
accept that. Thank you, sir.
Thank you.
Okay, the plaintiff then, have you rested your case there, or do you?
Yeah, plaintiff rest, Your Honor.
Plaintiff rest, okay.
And defense rest.
Defense rest. So no closing comments, or do you have closing comments?
If the court would prefer, I would like to make a few closing comments, Your Honor.
That would be fine for both sides.
Thank you. Okay, so here we are, under 122404, which is the provisional remedy, and as you've already recited at the beginning of the proceeding, there's really only two very discrete issues, which happen to do with the statutory requirements for the issuance of that remedy. We're not here in a sense to determine that plaintiff wins, defendant loses, and I want to just make sure that both parties understand that as well too. In terms of, we don't have a trial date in this case, so right now plaintiff, as you can tell from the testimony, is without the property, defendant is in possession of the property. Plaintiff is in a sense just seeking that provisional remedy in which she gets to be back in possession, rightful possession of the property she owns. The evidence I think that was fairly compelling that the court heard was that not only was she owner in the past over the last 14 years, but that ownership never divested in any form. That testimony didn't come out just through plaintiff, it came out through defendant herself, through a series of admissions, including an open court, in which defendant repeatedly said, that is correct. Plaintiff owns, defendant doesn't own. So there should be zero question of ownership of the property. In terms of demand made by the rightful owner on the possessor, I think the court heard that. There was nothing that the defendant presented or provided that said no demands were made, or the demands were unreasonable, or the demands were untimely. So in terms of meeting the statutory requirements of I own, I let possession occur, I demanded back, all those things have been met well beyond the preponderance of the evidence. In terms of when a defendant is in possession and says somehow that the possession is not wrongful or they have an excuse to possession, the only thing the defendant apparently constructed, which seems to be fairly last minute, is two things. One, disingenuous argument that, oh, actually it wasn't really the defendant herself, it was simply this corporation that somehow she belongs to but doesn't somehow control. To the extent that defendant needed to put on evidence to show that that was the agreement, defendant doesn't have a signed contract, defendant doesn't have any evidence to the court about principal and agency. There's nothing defendant presented that said, oh, well, I was just an agent of a principal in which the principal was the one that was actually responsible. I didn't have authority to actually make any of these agreements. The court has already seen the evidence indicating all the pronouns that say you, me, I, her, all the things that indicate that these were two individuals dealing with each other. There is nothing in either the court transcript from the previous proceeding or in any of the evidence other than what defendant scrambled up with at the last second to indicate that somehow there's a corporate entity involved. Even to that extent, if somehow that seemed to have some impression on the court, the defendants in this action are not just the individual, but they include Arizona Animal Sanctuary. They have been properly served, they were noticed. The application for the writ of possession was served on those defendants as well. Defendant didn't put on anything to indicate that somehow the court doesn't have jurisdiction of that corporate entity, which it does. So to the extent, and I have proposed order for the court, to the extent that the order needs to reflect that the order is whatever it is, granted or denied, but to both the individual and the corporation, that's perfectly within the ambit of this court's power to do so. As to the defense that, oh no, there was actually a contractual agreement completely distinct as to what you actually heard in testimony from plaintiff, that somehow plaintiff actually let her property not just be in the possession of the defendant, but for the rest of its natural life, that she relinquished all ownership. That was, not only was the rebuttal testimony fairly clear, but I think the documents themselves make it fairly clear, there is no such agreement like that at all. Not only just on the formalities of having a signatory to the agreement would be bound by it, but just in the generic sense that someone who actually is supposed to adhere to a contract knows and recognizes the terms of the contract and says, I get it, that that's what I'm agreeing to. So nothing on Exhibit B, even the fact that somehow, if the court is somehow persuaded that that was on the back of Exhibit B, indicates that that is now some sort of integrated contract. It's not. I don't have, I think, the need, or nor does the court probably have the time for me to go through the Arizona case law in terms of what an integrated contract is, but we would probably have to have significantly more in order for that to somehow be a valid defense. The defendant is saying, no, actually the terms of the agreement were something else. Not only do we have plaintiffs saying under oath, in fact, what the terms were, and that was not taken apart or across. But then again, if we refer to Exhibit 13, that whole court proceeding in which Ms. Meerhoff said, "It's not mine, I'm giving it back. In fact, I'm perfectly fine with all that." Those statements, whether she was trying to state on the sense that, oh, they weren't scrutinies under oath, she agreed that they were still truthful statements anyway. She is bound to those as admissions. Those admissions and plaintiff's evidence seem to me to make an overwhelming case that the statutory requirements have been met, Your Honor.
Thank you. Did you have a closing comment?
Yes, Your Honor, thank you. Just to set the record straight, defendant has never said under oath that she wanted to keep the animal for its entire natural life. She said quite plainly that she was keeping the animal specifically for medical purposes in order to help the monkey, Latoya, to become whole again. We have had no testimony whatsoever about whether that was possible or not, but the plaintiff has already admitted on the stand that Latoya had medical problems and that she was to the point of asking someone else to help her with the animal. The sanctuary has a board of directors, of which Ms. Meerhoff is one, and I believe it has come across quite clearly that she believes that when she speaks to people, she is speaking of the sanctuary, but she has mixed it in with her thoughts that she is part of that sanctuary. And she certainly has never said that she would not give the animal back should it be stabilized medically. Thank you.
Okay. All right. After hearing, I appreciate the efforts of both sides in this case, but after hearing the evidence, a couple of points to be made first, although not as eloquently as you two can do, I'm sure, but the court notes the ownership of the primate, proper term? Primate, was for 14 years. The defendant never said she owned the primate, the plaintiff never signed the document manually or electronically that was presented in court today. This started out as only temporary ownership. I believe, if I remember dates, this is supposed to be returned to the plaintiff on November 4th. We're 7 months into this, so I'm having a little trouble defining temporary at this point, okay? So I mentioned no signature on the contract. Defendant did state that the Poe, the plaintiff, does own the primate. No question on that, okay? So I could issue an order, but if you have an order to present, sir, it'd be much more eloquent than I could sit here and do that. Yes, ma'am. Allow me a few seconds to look at this. Okay?
Of course, Your Honor.
Okay.
And just so the court knows, my representation is that I took the language of this order both from the procedural rules, the Arizona procedural rules, and also from the actual statutory language itself under ARS 12.2403 and 24.0.
I know that I would never remember the numbers, but yeah.
Thank you. I also would want to point out to the court, simply for safety's sake, based on that, whatever that defense ostensibly was attempted, that I have in this proposed order that refers to defendant generically. I think probably that it would be appropriate that that be made plural and be defendants, because it refers to all the defendants.
Sure.
Thank you.
Okay. All right, I'll read the order.
Yes.
My order is this matter having come to be heard in open court on May 19, 2016, on plaintiff's application for the provisional remedy of possession, and the court having considered the application and all evidence in support and against, having heard oral argument on the application, and having reviewed all applicable papers therein, it is hereby ordered that the application is granted. Can you hear me? 'Cause I'm not sure.
No, we can't hear you.
It is hereby, do I need to repeat that first part then?
No.
But you couldn't hear me.
Repeat it on here.
And somebody holler at me if this conks out again, okay? This matter having come to be heard in open court on May 19, 2016, on plaintiff's application for the provisional remedy of possession, and the court having considered the application and all evidence in support and against, having heard oral argument on the application and having reviewed all applicable papers therein, it is hereby ordered that the application is granted. Pursuant to ARS 12-2403, the court specifically finds all statutory requirements for the issuance of such provisional remedy have been complied with by the parties seeking such remedy. An application and notice for issuance of any provisional remedy has been filed with the clerk of the court, and copy of such notice and application have been served on the party against whom any remedy will operate. The parties against whom any provisional remedy is sought has been afforded, or have been afforded, an opportunity for a hearing, or a hearing has been held as provided for under ARS 12-2403. Pursuant to ARS 12-2410D, the court specifically finds there is probable cause to believe the claim of the applicant is valid and that the statutory requirements for any provisional remedy have been met. Pursuant to ARS 12-1302, the court hereby orders the county sheriff or constable to take the 14-year-old black-capped capuchin monkey, and I hope I said that right, named Latoya, with AVID microchip number 072842842 from the defendant and deliver it to the plaintiff. So ordered on this day, May 19th, 2016. And as I said earlier, that was said more properly than anything I could say, so I do appreciate the order.
I have two matters for the court.
So we've settled that matter right there. Now, we're not done.
No.
Okay.
Okay. So the second part of the provisional process hearing is both, it is part of a practical thing and then a financial thing. And I want to address both in turn. The practical thing is where the property actually is located, when the property will actually be returned, if voluntarily so, or to the extent that a writ of assistance needs to be sent to the sheriff to have the sheriff actually seize the property, how that would work. I think it's usually appropriate to have the defendant weigh in if they're just going to voluntarily comply with the court's order, and if they're not, then I would seek that writ of assistance and have the sheriff actually serve process on them. But probably in order to do that, I think one thing that we need to know is the actual location of the property.
Okay. So I'll go to the defendant. A couple of things, I think he's talking about a couple different things here, the location of it, and how do we intend to return the property. And I'm the judge up here that sits, and I don't like to see costs escalate in any manner, okay? And I think they probably already are in this case. But would it be a voluntary return to Ms. Pohl? So where is the property located, and are you willing to voluntarily return on your own the property to Ms. Pohl? Am I saying that the way, do you have any objection to the way I said that?
I have no objection on that as well.
Good. On the first question as to location, my client tells me she does not know. I mean it. I'm sorry. The reason, I'm not going to tell you the reason not on the record. She was seeking medical help. Another sanctuary came forward and said that they could help the medical problem. It turned out to be much more than valley fever, according to the
That may be true, but I think we're past the point on what the primate has and what it doesn't have.
Right, no,
We're talking
but there
about
were more
return.
people who said they thought they would be able to help medically. A sanctuary, and it again was incorporated, and as I understand it, they were well known. So she asked, or they said they could provide help. Ms. Meerhoff accepted the help, and
Okay, I appreciate that, but I don't appreciate hearing that you don't know where the animal is.
well, I don't.
Because a phone call or
She
something.
doesn't know. So she does not know, and that's,
May I address that?
I'm so sorry, but she does not.
Yes,
So, in my experience, at this point of the provisional process hearing, it's appropriate, once part of the court's evidentiary determination of what's due about enforcing the order is to put then the property holder back on the stand and
Yes.
find out those things.
Yes.
So I would request, actually, plaintiff would request that defendant be put under oath again.
Okay, Mr. else?
Thank you.
I'm sorry, I heard somebody say something.
I said thank you.
Oh, okay, Ms. Mayor,
Can I have just a minute to say a word to my?
I'll give you a minute, okay? Good to see that you're still in there, old man. Okay, sir, proceed.
Thank you, Your Honor. Ms. Muirhoff, what is the last date you were in physical possession of the Monkey Latoya? Day, month, and year, please.
November. And I would have to check for sure on the date, shortly after Thanksgiving. But I would have to check on the date because I don't want to tell you wrong.
Can the witness be presented with Exhibit 13 again?
Okay, I'm sorry, sir, I was taking care of some
I
other.
apologize, Your Honor. Could the witness be presented with Exhibit 13?
Softly thick, man, there you go.
Ms. Muirhoff, if you could turn to page 15, please. Take a look at the top of 15. Take a look at line 5. The court was discussing with you exactly this issue, and Judge Moran said, I want to know where the monkey is. I want to know where the monkey is. Do you see that?
Yes.
And you said, the primate is in Texas right now. Oh, installation in Texas. Do you see that?
I see that.
Okay. What installation in Texas was the primate at on January 8th of 2016?
I don't have any idea.
What were you referring to when you said to the judge it was the installation in Texas?
I didn't say installation.
Take a look at Exhibit 13, page 15, your words, line 11, installation in Texas. Do you see those words?
I see those words.
Okay, were those your words?
No.
Okay, Your Honor, I have an audio transcript of that proceeding, if it helps the court to be able to listen to that. And I have a way of playing that as well, too.
Oh, that'd be fantastic. I trust your equipment more than I do mine, so that's great.
May I have a minute?
Of course.
You can be the one to know how to look this back. Make sure it's easy. Hope what everybody sees you do.
CD 15-034-928. You have counsel for Ms. Huddle? Correct. Okay. Is state your name, please? John Corvina.
Your Honor, since this can be difficult to fast forward, do you mind if we just listen to it 12 minutes long?
GRA.
Oh, that'd be fine.
Okay.
That'd be fine.
And then we can stop at the point at which I want the witness to hear.
Corvina. And Ms. Muirhoff, you present? Ms. Muirhoff. Okay. Thank you. Did you have an attorney now? No. Okay. And I did know, Ms. Muirhoff, that I did receive a motion from you dated on January 6th asking to continue the hearing today for the purpose of, it sounds like attempting to get legal representation. Is is that right?
Yes, the notice of the court hearing, the wrong zip codes and things were put on the envelope, so we did get them late.
Okay,
So
all right,
it
sounds
takes
good.
time. But we're all good.
All right, sounds good. And, Mr. Gravina, we have a form that we can have you fill out for a notice of appearance. I'll have you fill that out here today, so we'll allow you to speak. What's the position of the plaintiffs on the motion to continue the hearing?
We object to it flat out. My representation is limited. And I anticipated this coming, and I have the evidence of coming on.
Okay, all right. Are you appearing today as an advisory council? Is that
Correct.
Is that essentially what you're?
Yes.
Okay, I'll make a note and it's Gravina is appearing as advisory council today. Only. Ms. Petto, you are present, correct? Okay, all right, thanks. Hi, the court has read the complaint, in this action. I will note that Ms. Muirhoff has not filed a response yet, to the complaint. However, essentially, it sounds like we have a primate monkey that is owned by that is alleged to be owned by Ms. Poe, that is in possession of Ms. Muirhoff. Ms. Muirhoff, do you have possession of the animal? Yes or no?
And rather than waste the court's time with 13 minutes of transcript that I don't think I'm able to fast forward to the exact spot, I will represent to the court as it can listen at its own convenience. Ms. Muirhoff's own words say exactly what the court reporter's transcript says she said.
And I have no objection to that, Your Honor.
And in refreshing all of our memories, the transcript was done in Tucson and Pima County Justice Court by
By a certified court reporter, and the last page of the transcript, Your Honor, actually is, on page 23 is the certification by the court reporter, Your Honor. She actually is an Oregon court reporter, not a Arizona one. Okay, so Ms. Muirhoff, if we could go back to that, assuming that we could hear your own voice say, say the words installation in Texas, would that probably likely be your voice saying those words? To the extent that the judge has to listen to that and hear your voice say the words installation in Texas, would you agree that's your voice?
I don't know.
Okay, well, I'm sure the judge will be able to determine that.
I probably just don't understand your question, sir.
Sure, my question is, under oath right now, in January 8th of 2016, did you tell a judge in open court that the monkey was at an installation in Texas? Simply yes or no.
I didn't use those words. I did tell the judge that she was in Texas.
Okay. And well, the judge can determine for yourself whether right now, under oath, you're being untruthful with the court or you're being truthful. But in the sense that you don't maybe recall that you used those words, I'll represent you that the tape recording shows that you used those words. What installation in Texas, or facility, or building, or corporation, or company, whatever it is that you want to use the word for, what is that place?
I have no idea.
You have an idea of the city in Texas?
No.
How about a county?
No.
How about some general part of the state, northwest, southeast?
Honestly, I don't even know that she's in Texas anymore.
So were these words to the court, were these untruthful statements?
No.
Okay, I'm sorry?
No. No.
Okay.
No.
Okay. Why is it that you even referred to the state of Texas at all then? What made you know that there was even involvement of the state of Texas and where the monkey was located?
Because that's where I took her.
Okay, so where did you take her?
To Texas.
What city? You're under oath, Mr. What city in Texas?
I'm not trying to lie. I'm trying to remember, sir.
Okay.
I do have it. I have a receipt at the motel.
The question is, what city in Texas?
I don't know.
Okay.
I would have to look it up in my paperwork.
Could the witness be allowed to go do that?
Sure, you got it here.
Yeah.
Yeah.
I got my receipts and everything.
She didn't turn her thumbs on. It's San Antonio.
Do you want to give everybody a copy of? These are my receipts in route.
The question is just a witness, if she's up at the stand, and that will help refresh her recollection, so she can put into the record what she knows, that would be great.
Yeah, just bring that with you. Well, bring it with you, bring it with you, yeah.
Did you care for the copy?
No, no.
Didn't she get a signed contract? Didn't she get a signed contract?
I took her to Big Springs, Texas.
Okay, and on what date did you take her there?
I would have to look in my other paperwork, I'm sorry.
Go ahead.
And I don't have that with me.
Okay.
I'm sorry.
Do you recall what month or week?
Like I say, November. I already stated it was November.
Okay, and who did you meet in Big Spring, Texas?
I met with no one.
Drove to the city of Big Spring, Texas, and met with no one?
Yes, sir.
So didn't you just then drive Latoya back with you then, back home?
No, sir. I was told to check into this motel, leave her in the room, and leave for about an hour. I did exactly what I was told, and I came back and Latoya was gone.
Okay, so,
That's exactly what I was told to do, and that's what I did, under the circumstances.
okay, so let's determine then who told you those things. Was this a man or a woman?
A man.
And what was their name?
I have no idea.
What was their phone number?
I don't know.
And how did you did this person call you?
It was a phone call through Messenger, and I had received several.
On what date did you receive that phone call?
I don't know.
And how did you get instructions as to where to go in Big Springs, Texas?
Through a phone call.
And did you record that phone call at all?
I have no way to do that.
Do you have any sort of writing or memorization of that phone call? A journal entry, a log note, any sort of record of it?
No,
And you don't know the phone number of the person who called you?
no,
And do you know who that person was?
no.
And were they a stranger to you then?
I don't know who it was.
Right, so they were a stranger to you. Is that correct?
I have no idea because I don't know who it was.
Okay. So someone who you don't know who they were calls you from a phone number that you don't recognize, tells you to go to a place and leave a monkey in a motel room, and you did that. Is that correct?
Yes, sir, I had had 50 offers of people wanting to help the sanctuary all over the country. People wanting me to go ahead and give her to them so they could finish her care and help her to get well.
So were you acting in the capacity of the Arizona Animal Sanctuary when you received that phone call?
Was I acting what?
In the capacity as an agent for the sanctuary or a representative of the sanctuary?
No, sure.
Okay.
Everything dealing with Latoya.
And so then when you drove to Big Spring, Texas, did you drive in your own car with the monkey? You drove the monkey to Big Spring, Texas, correct?
Yes.
Did you go with anyone?
No.
Okay, and when you got there, as a representative of Arizona Animal Sanctuary, you considered it part of the corporation's goals or plans, I guess, to deliver a monkey to a motel room and then leave it there, is that correct?
No, the idea was to get Latoya to safety because we had had death threats. People were going to bust down our gate. We have it in text message. We have it on voicemail that people were going to come in and attack and kill every animal on the place. We were doing our best to protect Miss Poe and Latoya.
On the date that you left them, what was the motel actually, by the way? What motel?
Excuse me?
What motel was it?
It says Days Inn.
Okay. And do you remember talking to anybody at Days Inn that you were doing this, that you had a monkey, that you were renting a room, that you left the monkey in the room?
No.
Okay, did you actually rent a room that day?
Yeah. Yes, the paper that you're holding is a receipt. It's a transcript from my bank
Okay. Is this
that
from-
tells everything the whole route.
Okay. This bank, is this your personal bank account or is this Arizona Animal Sanctuary's?
I don't know, I'll have to check.
Okay. And in terms of then, either you or the sanctuary is the one that rented the room, is that correct?
Excuse me?
You rented the room? You paid money to rent a room at the Days Inn?
Oh,
Okay. That's how you got into the room, correct?
excuse me?
Is that how you got into the room? You rented it, paid money, got a key for the room?
Yes, I did it legally.
Okay. And then in doing that, did you make any attempt to determine who was going to then pick up the monkey at all? name, identity, gender, anything about them?
No.
What was the reason for that?
For what part of your question are you asking?
What was the reason why you would take a monkey that you had promised to take care of and leave it in a hotel room to someone who you didn't know and didn't make an attempt to find out who they were?
I was given documentation from several different primate facilities throughout the United States. People knew what was going on, and the death threats and the threats towards LaToya, the threats also towards Miss Poe. We had absolutely no idea as a corporation where these threats were coming from, because Miss
And
Poe
your answer
specifically
is-
said that
your
it wasn't
answer-
her. So we were trying our best to protect the primate and get her to safety and get her medical care, because her vet here in Arizona had been threatened and harassed to the point where he would not see animals from Arizona Animal Sanctuary or LaToya.
Your
And I
Honor.
have documentation of that.
Ma'am,
I would move to strike all of that as non-responsive.
And he asked me why.
May I-
That's why. You asked me why, that's why.
May I continue?
I'm sorry, ma'am.
I just wanted to say thank you.
Am I correct in thinking that that was the last date that you physically had the monkey in your possession?
Yes, sir.
Did you ever learn from any source where the monkey was after whatever that date was in November?
No, sir.
So on January 8th, in open court in front of Judge Morin, did you then, when you said the primate is in Texas right now, installation of Texas, were you referring to a Days Inn hotel?
I'm sorry.
Take a look at Exhibit 13. Take a look at your words. Take a look at page 15.
Oh,
Take a look at what the words were that you said to the judge in open court about the primate is in Texas. When you said that phrase, were you referring to the Days Inn hotel?
no.
What were you referring to?
The state of Texas.
As to the way that anyone would have received your phone number to give you that message to call you, how would that have happened? Had you posted your phone number on social media? Have you posted your number on Facebook?
My phone number and information is posted on Facebook, but it was also being strung out throughout the United States by people making threats and accusations. My phone number was placed in places that I've never heard of before.
Okay, turn to page 16. And I refer you to the court's statement to you. And if you take a look at the top of page, at line 3, it says, this is the judge talking. Ms. Muirhoff, how long will it take you to return the animal? How much reasonable time will you need to get the animal back from Texas and return the animal to Ms. Poe? Do you see that?
Yes, sir.
And you see that your answer is, I would say 5 to 7 days we could have her back in a reasonable time. Do you see that?
Yes.
Was that a truthful statement to the court?
Yes.
Okay. How did you indicate to the court that it would take 5 to 7 days to have her back? What were you planning on doing?
I indicated that to the court by telling the court that.
No, I understand that. But on January 8th, if the court had said, okay, 5 to 7 days, what was your next step? What were you going to do in 5 to 7 days to then go obtain that monkey to return it to the court?
Within my best effort, contact the primate facility.
Okay, what primate facility?
I don't know.
What
I
phone
don't
number?
know what it's called or anything. Or I didn't have a phone number. It was through Messenger.
Okay, let's see if we can get this down straight.
Okay.
You did have a phone number or you did not have a
I
phone
didn't. They contacted me, just like all the other facilities across the United States have been contacting me.
So when you told Judge Moran, I would say 5 to 7 days we could have her back in a reasonable time, was that a truthful statement or an untruthful statement?
Just like
Listen to my question.
just like it's written here, I would say 5 to 7 days, and it was truthful because that's what I thought I could do, that's what I believed I could do, and that's what I wanted to do.
So tell this judge the steps that you would have taken, the specific steps, in 5 to 7 days to obtain that monkey and bring it back to the court. What were the steps that you were going to take? Even if it would have taken 8 or 9 days, what were the steps?
The steps were that it was going to be posted all over Facebook, and I would wait, and they would contact me.
What was going to be posted on Facebook?
The fact that the primate was gonna be returned, or that we were gonna do, everything in our power to return her.
This was going to be a message to whom? To whoever would read
A
Facebook?
post.
So you're gonna present
And
an
I also,
open, listen,
well, I'm sorry.
you're gonna present an open message to the community and hope that whoever actually had taken that monkey from the hotel room would read the post on Facebook and then would comply with it and return the monkey. That was your plan?
That's the only plan I had. That, and also, Miss Poe, I knew her and her friends would be posting it. I knew everyone out there would know what was going on.
Did you, on November, when you actually got the message from whoever sent you the message, and then made your plans to get in your car and drive to Big Spring, Texas, did you say any of that to Ms. Poe?
No,
Did you tell her you had been contacted by someone?
no,
Did you tell her that you were going to Texas to go take the monkey to someone else?
no.
What is the reason why you were not informing her of this plan to leave the monkey in a motel room?
Because the death threats that were coming in and all the other threats that were coming to the veterinarian, and Bonnie spoke under oath, swore that it was not her and that she was not doing the harassment or the threats. So us as a corporation did what we thought was best to protect Miss Poe, to protect the corporation, and to protect LaToya.
Take a look at page 18, please, of Exhibit 13. Take a look at the top. The court asks you, so you have some incentive as well in this, in getting the animal returned. Do you see that?
Yes,
Are you there?
yes,
Okay, and you see later on in the colloquy, it says, when you're talking, you say, oh, absolutely, and honestly, Your Honor, I wanted to end this before I came to court, and then you say, we just want to return her now that she is doing better and all. Is that correct?
that's what it says.
Okay, so to the court on January 8th, you indicated the monkey was doing better. Is that correct?
Better than when Miss Poe surrendered her to the sanctuary, yes, sir.
Good enough to leave in a hotel room by herself so the stranger could take her. She was in good enough condition for that to happen.
She was immobile.
So when you said to the court, we want to return her now that she was doing better and all, was that a truthful statement? Was it truthful that you said to Judge Moran that you did want to return her and that she was doing better? Is that truthful?
That was the absolute truth. The sanctuary did want to return her because of all the death threats, but we didn't know how to do it.
Okay, and what was...
And she was doing better than when Miss Poe surrendered her to the sanctuary for care. She was definitely doing better.
Sorry, one second. Some indication that you know of a person in Texas with whom you've been in communication about the monkey LaToya. Is that correct?
Can you repeat that, please?
Sure. There's some woman in Texas whom you've had regular communications with about the monkey LaToya. Is that correct?
I'm not sure who you're talking about.
My
There
question-
are,
Well, Margaret Husseini, is that correct?
what?
Is that she's a woman in Texas who you've had communications with about LaToya? Is that correct?
I have had.
Okay. Did you talk to her about this plan to take the monkey to Big Spring, Texas to a...
Absolutely not. I told no one because I had absolutely no idea where the threats and death threats were coming from. The board at the sanctuary and myself are the only ones, and my husband,
Who know what?
that knew I was going, and that knew that LaToya was going to be transferred out of state for her own safety and so she could continue medical care.
So besides the fact that you're going to a city in Texas, did you tell the board, your husband, any other details?
Who's the other woman that has the
No,
in Texas?
no.
No, I don't want you to, of course, time with a fruitless endeavor. I don't think I have any other questions for this witness. But I do have a matter for the court.
Do you mind a tree as witness asked.
I'm sorry.
That's just my first name.
I guess all I can ask at this point is, do you have contacts in Texas?
No, at this time, when we attempted to make contact, in fact, they did contact me through the Facebook post like I assumed that they would. When they contacted me, Judge Moran gave till the 22nd for a status review because he wanted to give me extra time, feeling that maybe 5 to 7 days wasn't enough, which is also in the transcripts. We were beginning conversation. The conversation headed to that we were making steps in order to return LaToya to Arizona, possibly. Her care was in such good order, but definitely they wanted to start communication and open lines of communications with Miss Poe, her previous owner. At this point in time, Miss Poe and her friend John Gravina went on news TV in Texas, actually entering people's private businesses and making accusations, threatening people that they were going to file charges.
Okay.
And that is why all communication stopped.
Okay, but you had communicated with some people in Texas, had you not?
Yes, ma'am.
And you could communicate with them again, couldn't you?
The people that I am in
And you don't
touch
have to
with.
do it necessarily by social media, do you?
There are people in Texas, yes, that I can talk to.
But would it be possible for you to ask the specific people maybe to call the sanctuary so that it doesn't, so that the conversation doesn't go all over the U.S.? Could you do that?
The people that are involved with LaToya,
Yes.
I have made attempts. I have definitely made attempts, but after everything was on the TV news in Texas, they have severed all ties. They will not contact me. They will not talk to me. They will have nothing to do with me for fear that the same thing is going to happen there that happened here in Arizona.
I don't know what else to ask, Your Honor, so.
Thank you. Okay. Anything else, Mr. Cook?
Just one question, Your Honor, actually. So it's the statement you just made under the cross. You said there are people in Texas I could talk to, people involved. Could you give me a name of those people?
I did not say people that are involved.
I just wrote it down as you said it. There are people in Texas I could talk to. There are people involved. Those are the words that I just heard you say.
I'm sorry, I started to say another sentence. There was a gap in that, and I did start to say another sentence. I was going to ask Ms. Gratz if she meant people that were involved with LaToya. There are people in Texas that I know that I can talk to, but then I realized I was thinking the wrong line. She was wanting to know people that was involved with LaToya.
Is one of those people Sabrina Bourgeois?
I have never heard of that name. I'm not sure. I have several friends on Facebook that I don't even know who they are, but
Can you identify to this court any actual name of any person that would know anything about where LaToya is? First name or last name of any person that you could identify to the judge that would know something about the whereabouts of LaToya?
there's absolutely nobody. I know no names. For all I know, it could have been Bonnie or one of her friends, Miss Poe or one of her friends that picked her up at the motel.
No.
I don't know. I honestly don't know.
That would be so. Okay, no.
Well, I'm just trying to make you understand that I have no idea.
No other questions. Mr. Howe, thank you very much. You may step down.
Your Honor, another matter for the court then.
Okay, sir, I heard you right, so you have another matter.
Sorry, Your Honor, yes, just to, again, for the sake of completeness, I'm going to refer the court to ARS 12-2411. This is under the provisional remedies. Once a order has been issued, which it has, if a hearing is held pursuant to that section, which it has, and the issue, and the provisional, let's see.
I want to see if I've got 2.1 in front of me, so.
Right.
Okay, so start, okay.
So here's where I'm coming to. A provisional remedy would be where the property is actually returned. And it appears now that the property cannot be returned in a feasible way, correct? Or at least it seems to me that.
Seems to be.
Okay, so if no provisional remedy is issued in that practical sense, the court may award reasonable attorney fees to the party against whom the provisional remedy was issued or was sought to be issued. In other words, what I'd be asking for, and I submit this under petition, would be plaintiff to be awarded attorney's fees for the defendant preventing, in a sense, the provisional remedy from being able to be acted upon and enforced. And I could present that in the form of a petition, Your Honor, for the fees. But what I need to do is to make, I think, this defendant realistic about what sort of consequences those types of absolutely irresponsible to obtain the value of the property. But certainly in terms of this complaint and this action is not just for the provisional remedy, but these defendants have been sued not just for replevin, but for breach of bailment, trespass, child's conversion, and fraud. And there's money remedies that go along with that. We're not here about that today, right. And that's not one of our issues. So to the extent that there turns out to be a trial or another hearing in this matter, those remedies would be something that we would deal with then. What I'm asking for now is, because the defendant has effectively prevented provisional process from issuing, in a sense, I'd ask for attorney's fees for having done the things you just heard.
These fees would be reflective of
The amount of time.
until.
Yes, from what plaintiff is. Yes, for what the plaintiff has had to actually go through in order to obtain the provisional remedy, and now be stymied in being able to obtain the remedy. And I would ask that those fees be awarded against, of course, all defendants, not just Ms. Muirhoff individually, but the corporate defendants as well too.
Do you have a response to that, ma'am?
I'm just going to ask individually and separately as Arizona does. That's the way they will be in the order. In his affidavit, he will give us the amount, of course, broken down. And then,
Individually and separately as referred to.
As to the parties.
AZSC or.
right, all of the various parties. Thank you.
Response to that, sir?
Sounds fine.
Okay. So what's your pleasure? Do you want to draw up a,
Yeah, if the court would give me the leeway for a few days in order to be able to draw up that petition and then present it to defense counsel and then present it to the court, I would ask for like about a week to do that. Okay.
okay,
Thank you.
that would be fine. Do you need anything from me here? I am agreeing to that, what you just said.
I can submit a proposed order along just exactly those lines. I can do that, Your Honor.
All right, is there anything else that needs to come before this court today?
Not on behalf of plaintiff in terms of this remedy, Your Honor.
Okay. Any final comments, ma'am?
No final comments. Thank you, Your Honor.
Okay. So we have the order, okay, we will await, what you just heard, from, the Attorney Duckler in favor, in favor, and, here for the plaintiff. Well, we didn't resolve today. Where's Latoya?
However, I still have some thoughts on how that might be accomplished. I don't know.
Well, apparently it's not going to be accomplished.
Probably not, yeah.
I mean, that's what I'm hearing. Am I wrong?
No?
I hate to say that, I'm sorry. I'm
No,
trying
no.
to be realistic based on what I've heard.
And I appreciate it, Your Honor. That will be a very expensive mistake for a defendant to have made, obviously, based on what the rest of this action is going to do. But that's the mistake that she selected to do.
Okay. So at this point, then, having no more action that can really legally come before the court today, I will await what you present to us in the form of an order and,
Thank you.
in the next, well, what do you think, a week from now, 7 days?
If I could have 7 days, that'd be terrific. I can get
Well, let's
to-
say by Friday of next week, which is, well, you know what, we're getting into Memorial Day holiday, so do you think Thursday will be fine?
Thursday of this next week or the week following.
What date was that?
That'll be the 26th, I believe,
Okay.
1 week from today.
I can do
I don't
that.
want to put you in a situation
No.
you can't, and I'm sure you will.
Right.
I can be pretty productive within a week, Your Honor.
Okay.
Okay, thank you.
All right, I thank you all for being here today, and I wish we could have accomplished more, but,
And may I have a copy of the signed plug in order then?
As could I.
yes,
Thank you.
take care of that. Thank you all for being here this hearing.
Thank you, Your Honor.
She's not right. She is.